Yeah, I'm back, y'all. I'm back. I had to switch it up a little bit. All right, we back on it. We back in it. So I wanted to get back on what I was saying about uh, when I was talking to the creator, right? So as I'm asking, the creator to reveal itself, I'm trying to turn back to see. But as I'm trying to turn back, I can't move. So I kept asking, let me see. Let me see who you are. Let me see you face to face. We want to embrace your presence correctly. So I kept, I asked one more time for the creator to allow me to see him. Now, this was in a vision. Now, remember, I'm only visioning. I'm having a vision, a deep state, in a deep state, in a deep thought. But in this deep state, I'm talking to the creator. After the second time of asking to allow me to embrace his presence, I was able to turn. So as I turned and I looked, it was me. I was standing in front of myself, full body, in space, just standing there. And I'm standing on this side, and another me is standing on this side. So I'm looking, my heart racing, because this is weird. And the reason why I say that it was weird is because I'm talking to the creator, to God. And I'm asking God to please allow me to embrace his presence, to allow me to see him, because he's talking to me from behind. I hear his voice, but I want to embrace his presence. And like I said, I couldn't move. I couldn't turn. I was trying, but I was not allowed to turn. So I kept asking and pleading, like, let me embrace you. I want to correctly acknowledge your presence, to see you, to talk to you. And after asking 2 times, I was able to turn around, y'all. I was able to turn my body. And when I turned my body around, because when I was facing forward, it was all white. It was all white. All I seen was like a white light, all white. But when I turned around, it was all dark. It was all black. So, but it's me standing in front of myself. Now, this is weird. This is weird because I'm talking to God. So when I see myself, I immediately get a heart race. My heart started racing, and I told you I'm in a deep state. I'm really actually visioning this because I'm actually awake, but I'm like dozed off into a zone, right? I went into a deep state. So my heart racing because I'm looking at myself, but it's like a mirror, right? But it ain't no mirror though. This ain't no mirror, y'all. This wasn't no mirror. It was me standing in front of me. So what made me come out the vision, I'm looking at it. So I did a move and it didn't move. My heart really started racing. Then it started smiling at me. And when it started smiling at me, I woke up out the vision and I was like, what the hell was that? What was that? It only happened to me one time. That's the only time that ever happened to me. Like where, I was talking to the creator and I happened to turn around and it's me talking like, that's man. So, as I got older or whatever, as I began to unfold in my understanding, I understand it a little bit better now than then, So, you live and you learn. But let me share this. Let me share my screen with you real quick. All right. So as I was saying earlier, if you've been with me, we were talking about the Fair Debt Collection Practices Act, and we were talking about false implications, okay, where, you have a lot of officers and a lot of agencies within the United States that are falsely perpetrating to be something that they're not. And what I was going over was we were talking about attorneys and how attorneys are not actually true attorneys and that they are giving false representations, right? So I took them to the FDACAP, right, the Fair Debt Collection Practices Act, and what I was doing was showing in this act where it says right here, number 3, it says the false representation or implication that an individual is an attorney or that any communication is from an attorney. Now, what I was speaking on was like, when you hear that, it's kind of hard for you to deal with that because in most of the courtrooms and things like that, these people are posing or saying that they are attorneys. But when you go to the federal law says that anybody that's faking like they're an attorney basically is representing themselves falsely, right? So what I wanted to do is show the people the truth, right? So we're gonna go to the Attorney Act. Okay? And I say they got this act for each state, right? And since I'm here in Illinois, we're gonna pull up Illinois Attorneys Act, okay? And we're gonna read this, all right? Let me share my screen with you guys so you can see what I'm reading from, okay? Now, in this act, it says short title. This act may be cited as the Attorney Act, okay? Now, I believe in teaching the people. I don't believe in telling you things without showing you proof. All I ask is that you share my video, and give me the likes, show the love, in return, help me get out to more people and get more recognition because I truly deserve it, right? Now, in this act, it says, no person shall be permitted to practice as an attorney or a counselor at law within this state without having previously obtained a license for that purpose from the Supreme Court of Justice. Now, I don't know if you knew that, but now you do. Now you know the truth. All right. So when you're dealing with these so-called attorneys that are perpetrating, faking, and trying to tell you that they are true attorneys, now you know the truth. If they have a bar badge from the bar, that's not a true attorney. Okay. You have to have a license from the Supreme Court. And if anybody's communicating with you, writing you, saying anything that they are attorneys, now you got some ammo. Okay. All right. So all of this, like when they say the representation or implication that non-payment of a debt will result in an arrest or an imprisonment of any person or seizure, garnishment, attachment, or sale of any property or wages of any person unless such action is lawful and the debt collector or creditor intends to take such action. You see what I'm saying? Then the only way somebody could collect something that's yours is if you're not claiming. Or you're afraid to claim it because you don't understand that ownership gives you entitlement. You see what I'm saying? And when you're not claiming ownership, anybody can have possession, and possession, 9/10 of the law is to like uh uh 9/10 of the law is possession. So title can be a person can have title to property just by possession, but not directly be the real owner of the property just because they have possession of it. And that's something that we also have to learn, right? Now, in this Fair Debt Collection Practices Act, this is talking about all the false implications that they take, you know what I'm saying, and far as uh, falsifying records and saying that like when they communicate or threaten to communicate to any person credit information which to be known to be false, including failure to communicate that a dispute a disputed debt is disputed, like that too, like the credit bureaus, like if you dispute something on your credit profile, they have to put it in dispute status. It's supposed to be showing that it's disputed. You see what I'm saying? Like it's a lot of different things. Even with a company, when you write them and you say you dispute, if it don't show that that debt is dispute, then that's in violation of this code. Okay, period. You know what I'm saying? And the reason why, uh, like a lot of these agencies that claim that, see, like you know how you say, I know you've probably dealt with a company, like say for instance, maybe the gas company, maybe the water company, or maybe a phone company where you've tried to enforce this law right here. And they'll tell you, they'll say, oh, well, the FDACP don't apply to us. We are the original creditor. You see what I'm saying? They'll say something to that degree that they're the original creditor and that it don't apply to them, right? But you are the creditor. You are the actual creditor. You are the actual real owner over the account. You know what I'm saying? And they are actually just the holder, all right? Holding the account, acting as the creditor. They're acting as the creditor. You're the actual creditor. They are the creditor for the services, right? When as far as maintaining the account and all of that, they are the creditor in that sense. But you know, when you're dealing with ownership, you are the actual true owner over the account. So their interest in the account is it doesn't stand to your ownership rights. Your ownership rights stand over their security interest in the account. Uh, let me see. All of this right here is dealing with false implications and things like that. All right. So when you're dealing with the Fair Debt Collection Practices Act, I understand that uh, they're collecting they're collecting debts solely for the administration of uh, security interests. A lot of these companies are not debt collecting agencies. They are collecting a security interest, an interest that somebody promised or somebody signed and gave an agreement to do something or something to that degree. And that's what they're collecting on. They're not actually debt collection agencies at all. Now, in the Fair Debt Collection Practices Act, when you're actually dealing with a debt collector or somebody's writing you saying that they're a debt collector, you do have rights. Now, according to the FDACP, you got the rights to tell them to validate the debt, and you can send them a notice of this within 5 days after the initial communication. So before, like I had to read this to figure this out, right? So a debt collector may not communicate with you about a debt without your consent, right? So let me see. Let me see if I can find it real quick. All right, so that ain't it. It's down a little bit. All right, so let me start here. It says right here, it says within 5 days after the initial communication. Now, initial communication, right, with the consumer. All right, so anytime they communicate with you, like over the phone or anything like that, and they actually make contact with the consumer, that's considered as intercourse. All right, intercourse is when they actually connect to the actual person. So if they call and they say, "Hey, Isaiah Bay," and you say, "Yeah, this is Isaiah." They say, "Hey, Isaiah, I'm John DeRideau. I'm calling on behalf of such and such. This is an attempt to collect the debt. This, and that. Are you blah 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 blah?" Now they saying that they have made an initial communication with you, right? Because they've actually made contact, right? Now that's a violation because, and I'm gonna tell you why that's a violation. Let me show you something, okay? In this act, all right? They're not supposed to call you and approach you like that, right? When they call you, this is what they're supposed to do, right? Let me show you. All right, let me show you. All right, now right here it says communication in connection with a debt collection, right? It says without prior consent. So this is most important right here to me. First of all, they got to have prior consent to even communicate with you. All right. So who consent do they need? I believe they need your consent, right? So I'm going to show you how they get your consent. So it says without prior consent of the consumer given directly to the debt collector or express permission of a court of competent jurisdiction, a debt collector may not communicate with a consumer in collection in connection with the collection of any debt. So let's stop right there. Just that alone is powerful. So if they don't have your prior consent, right, or they don't have permission from a court, they may not even communicate with you, right? They can't even. So we ain't gonna read the rest of this. We ain't gonna read because all this is doing is saying how and all this about like when you at work and all that stuff, explaining that, right? And how when they communicate with third party, right? Now then right here it says ceasing communications, right? If the consumer notifies a debt collector in writing, and this in child support is also considered as a debt collection agency for the state. When child support collects uh, unpaid child support from for and on behalf of the state. So they are a third party debt collection agency collecting solely for state on all child support agencies throughout all 50 states. So now you understand that child support is also a debt collection agency. And you know, if I tell it to you, I can show it to you, right? Because I don't believe in just telling you that. I actually pull it up here in a minute and I'm gonna show you that child support is also a debt collection agency, right? I'm gonna prove it to you. All right. If a consumer notifies a debt collector in writing that the consumer refuses to pay the debt, or that the consumer wishes the debt collector to cease further communications, right, with the consumer, the debt collector shall not communicate further with the consumer with respects to such debt. And that goes for attorneys that's acting as debt collectors, trying to collect the debt for a dealership, for mortgage company, I don't care who they are, if they're acting like they're debt collectors or if they're acting and faking like they're attorneys, you can beat them to death with this act right here. All right. Now I'm gonna tell you like that. Now, now and it tells it said the only way that they can communicate with you is to advise you that the debt collector for the efforts are being terminated, to notify the consumer that the debt collector or creditor may invoke special remedies which are ordinarily invoked by debt collectors or creditors, right? Or where applicable, to notify the consumer that the debt collector or the creditor intends to invoke a specified remedy, right? So a specified remedy would probably be something that's written in that contract. Like usually they have like arbitration clause, they have different things that are already written in the agreement. Most consumers don't understand is when you write a debt collector and you tell them that you refuse to pay and that you don't acknowledge the debt as an obligation due to you, right? And you're demanding that he cease communications unless he has a written court order or a right to communicate with you, or else he'll be violating uh, your cease and desist order, right? So you give him a chance to prove his claim. If he can't, he has to decease, right? But you must understand that if that contract remains active, he still can enforce specified remedies against you, even report to your credit report. You have to rescind the contract. You have to cancel out the agreement. You have to, because if you keep it an active, open agreement, then he still can act under those terms. But if you cancel out those terms or you rescind those terms, he can't act on them anymore because they're non-applicable. Okay? In reference to your non-payment, or you saying you're not paying anything and you're demanding them, and you've rescinded the contract, so now he can't enforce no specified remedy. See, I thought I'd just throw that in there for you so you can understand when they say specified remedies, those are actual terms already written into the agreement. Okay. Now, now, now remember up here, take you back to the top. Remember right here, it says without the prior consent of the consumer given directly, right, to the debt collector. All right, now before we go here, prior consent, I'm gonna take you up here because I want to show you something. See, you got to learn how to read like this. And when you learn how to read like this, you'll be able to see how they're doing it and how you're getting jammed up. Okay. Show you something. Communication. Communication means conveying of information regarding a debt directly or indirectly to any person through any medium. So if I get on the phone with you and I convey information about a debt directly or indirectly, that's communicating. Okay? Communicating is consent. Communication is a form of consent. Why do I say that? Why does Brother Isaiah say that communicating with them is also giving them consent? The reason why Brother Isaiah says that, because it's just like the Child Protective Services is a public entity and you're private at your own home. Private and public don't mix. Without a court order, they can't trespass. But if you communicate with them, if you talk to them, if you open your door up to them, if you show them your child, if you don't demand that they get up off your property and demand a court order and demand that they're violating your privacy rights and demand that they leave, or else it's going to be a problem, then you're communicating. You're communicating because you're not asserting the right things in order to keep them from actually trying to involve with you. See, so when they communicate with you, whether over the phone or anything, that's a form of consent, right? Now let's check this out. Now I'm gonna take you down here. Because right here it says, right, without the prior consent of the consumer given directly to the debt collector, right? So most of you guys are giving consent. When you say validate the debt, when you write them and you say, hey, I want you to prove, you're giving them consent to communicate with you because you're saying validate, you're asking them to, you're participating with them, okay? But look, let's go down here. Go down here. Hold on, where is it at? Okay, so where is it at? Cease of communication. So when you write them, that's a form, but you can write them and tell them to cease. But it was a part in here where it says, where is it at? About deceptive acts. Right here. So when you go down, all right, so I just showed y'all above communication. All right, so communication is when they communicate with you. When they communicate with you, they're not communicating with you correctly because, matter of fact, I'm supposed to show y'all this. My bad. Let me get back up above because when they communicate with you, this is what they're supposed to call you and say. All right, let me show it to you. Let me see. Where is it at? All right. So when they call you on the phone, this is what they really supposed to say. It says any debt collector communicating with any person other than the consumer for the purposes of acquiring location information about the consumer shall identify himself, state uh, that he is confirming or correcting location information concerning a consumer, and only if expressly requested, identify his employer. And then it says right here, number 2, not state that such consumer owes any debt. So they ain't supposed to say you owe no debt and not communicate with such person more than once unless requested to do so, right? So when they talking to somebody on your behalf, when they talk to somebody on your behalf, they supposed to be trying to locate you and find out where you at, but they ain't supposed to be telling that person that you owe some sort of debt or that they trying to collect on the debt that you owe. But the way that they get consent is when they do this. When they call you on the phone, right? And they say to you, uh, hey, Mr. Lewis, then this, and that, because what they do is they don't ask for you. They automatically assume that it's you that's answering the phone. So when they call you, they automatically try to engage you as the person directly so that they can try to induce you to like talking to them as the person. So you know what I'm saying? A lot of them do that. They'll call you, they'll say, hey, Mr. Bay, how are you? And just like that, and try to talk to you. You know, wait a minute, who you calling for? You know what I'm saying? Stuff like that. So it's like, so within 5 days of the initial communication. So the way that they get you is they make an initial communication with you. That initial communication, like when they talk to you on the phone and you arguing with them about you don't owe nothing and I ain't paying you nothing and all that stuff, you know how we do it. We go in. We go all off on them and everything. We be mad in the mud when they be calling us about the debts, right? So when they make that initial communication with you, right? In connection with the collection of any debt, the debt collector shall, unless the following information is contained in the initial communication, or the consumer has paid the debt, send the consumer a written notice containing. So usually after they talk to you, that's when you get that little notice in the mail, right? Remember that? Tell you owe, how much it is, and all of that. So now the reason why you're getting that little notice is because they got consent. Right here. They were able to locate the debtor. They were able to initially make communication with the debtor, which gave them consent to proceed and move forward. It's just like with the courts. If they feel they have jurisdiction, they proceed and they move forward. Unless jurisdiction is a matter at hand, then they can't move forward. You see what I'm saying? It has to be a map, you know what I'm saying, at hand that's stopping the court from moving forward. That won't move. Somebody won't move. They stand right there. They keep saying, hey, we can't do nothing until you do this. Can't do no objection. You got to do this first. You can't hear none of that. Objection. Can't hear none of that. You ain't did this yet. I'm still waiting. Objection. You see what I'm saying? When that come down, they can't move forward. They can only move forward when you hear the case. When you allow them to say, well, you were, listen, this is an objection. You can't give no orders. You haven't proven jurisdiction, authority. Objection. You see what I'm saying? When you understand these things, man, it really changes a lot of different things, because you can pull the mask off the face of a lot of these people that's perpetrating and faking and using contracts and verbal and implicit contracts against you, that you don't understand. You know what I'm saying? In order to get your consent, or to get you to comply, to accept an order, or to accept, being responsible for something that they know that you're not even really responsible for, but forcing you in a way that makes you compliant, using uh, deceptive tactics, military tactics, war tactics. Uh, how they, I can't remember what they call it when they put you in a room, interrogating tactics against you that you're not familiar with, that you're not prepared for, that they study in high classes and stuff on how to manipulate certain situations to get a particular outcome in order to make things go a specific way. We have to enforce certain things. We have to give a particular image, and we have to have certain things in play in order to, because they know how, when you study human nature and you study the populace, in order to do certain things, everything is set up by design. This ain't set up just by coincidence. This is all design. It's all fear mongering tactics that put you in a state to where you feel inferior, you feel that you're outnumbered, or you know what I'm saying? And then you give in. Once your soul gives in, it's a done deal. It's pretty much a done deal. Okay? So remember that. Now, I'm gonna go somewhere else. Let me stop this for a minute. Get back to what I was saying. All right, now, so this Friday, y'all, I meant to tell y'all this coming Friday, I'm having a webinar uh, pertaining to processing uh, negotiable orders and processing payments with the banks and your local government, whether it's child support, uh, rents, uh, and other obligations. I'll be giving out two parts to this. This is going to be a two-part series where I deal with one part. We'll be dealing with all the laws, the rules, the regulations that govern all the different things that I'll be showing you, that I've actually learned on my own, that actually have been successfully working for me. And I'll be showing some of you guys the step-by-step processes that I've actually used myself and currently use to this day, in order to assign rights, property, uh, and other things. I'll be going over certain banking transactions. I'll be explaining in detail certain things about your debit card. Maybe you might not be familiar with the debit card and how to properly utilize the card to the highest potential. But if you come to this webinar, you will most definitely be more cognizant about what that little card is really about. and what you can actually do with it. Um, so I'll be covering things like that, and also uh, we'll go a little bit more into depository insurance, how that applies to all the funds in your account, and different things like that. How you are to get those funds returned back to you. Uh, that also, we'll be covering all those different things, and just wanted to let you guys know about that. So I look forward to that. I think I got a video up already with a link. So if you see the video and you want to actually tap in, make sure you get there. You know, like I say, don't meet me there. You better beat me there. Because hey, listen, information is something that you need. You need that information. All right, so let me see where I'm gonna go real quick. I'm about to go somewhere else real quick. Let me go into my let me go into the trenches real quick. Let me pull up something real quick. Now, when I go into the trenches, now they tell you, brother Isaiah got that info, boy. Woo, wee, boy, got that info. Boy, yeah, over here, like I'm gonna show you real quick. I'm gonna show you what I'm standing on over here, right? I'm gonna show you what I'm standing on. All right. Yeah, this is a little something for you, you know. Hold on, I gotta get my phone. Come on. But yeah, I got a lot of great. Oh yeah. I know what I gotta show y'all. Let me show y'all this real quick. All right. Because I said anything I say I can prove. I said child support is a debt collection agency. So I'm gonna show that to you. You'll be like, man, brother, I said, how you know all this stuff? I told you guys on the scene. Then y'all don't believe me, though. Y'all don't believe that the creator is on the scene, man. I'm trying to tell you. Now look. Don't say, man, brother Isaiah, I ain't never showed you. I'm gonna prove this to you today. Child support is a collection agency. Check this out. We got what's called the Collection Agency Act. Like, hold on. Collection Agency Act. Yes, sir. Yes, sir. The Collection Agency Act. Let's see what the Collection Agency Act got to say. Now, look, the Collection Agency Act is actually a pretty damn good act. Now, look, read this. The Declaration of Public Policy. This is public policy, y'all. The practice as a debt collection agency by any entity in the state of Illinois is hereby declared to affect the public health, safety, and the welfare, and to be subject to regulations and control in the public interest, because the people have public interest, and anybody collecting debts is collecting interest of the public, which is can affect the people's safety, their health, their welfare. Do it make sense now? I know it does. It is further declared to be a matter of public interest and concern that collection agencies, professions, merits, and receive the confidence of the public, and that only qualified entities be permitted to practice as a collection agency in the state of Illinois. This act shall be liberally construed to carry out these objectives and purposes, right? It is further declared to be public policy of this state, right, to protect consumers against debt collection abuse, right? Unless the content otherwise, the following terms have the meanings ascribed to them, right? The department means the Department of Professional Regulations, and the director means the director of the department, right? Collection agency or agency means any person, association, partnership, corporation, or legal entity who, for compensation, either contingent or otherwise, or for other valuable consideration, offers services to collect an alleged delinquent debt. That falls within the FDACP. Remember, it's an alleged obligation of a consumer. Remember that? All this stuff, when you start reading it, you'll realize how it all coincides together, right? This act does not apply to persons who collection activities are confined to and are directly related to the operation of a business other than that of collection agency, and specifically does not include the following: banks, including trust departments thereof, fiduciaries and financing and lending institutions, those who own or operate collection agencies, abstract companies doing an escrow business, real estate brokers when acting in the pursuit of their profession, public officers and judicial officers acting under orders of a court, licensed attorneys at law, right? It didn't say the in law, it's the at law, right? Licensed attorneys, insurance companies, credit unions, loans and finance companies, retail store collecting their own accounts, unit owners, associations established under Condominium Property Act, and their duly authorized agents when collecting assessments from unit owners, and any person or business under contract with the creditor to notify the creditor's debtors of a debt using only the creditor's name. Okay. Now look, child support indebtedness. Persons, associations, partnerships, corporations, and other legal entities engaged in the business of collecting child support indebtedness owing under a court order as provided under Illinois Public Aid Code, the Illinois Marriage and Dissolution of Marriage Act, and the Non-Support of Spouse and Children's Act, and the Non-Support Punishment Act, the Illinois Percentage Act of 1984, or other similar laws of which the state are not restricted in frequency of contract with an obligor who is in arrears, whether by phone, mail, or other means, from contracting the employer of an obligor who is in arrears, from publishing or threatening to publish a list of the obligors in the arrears, from disclosing, threatening to disclose in a range that the obligor disputes, but for which a verified notice of delinquency has been served under the Income Withholding for Support Act. So if you want to know what's going on with your child support, you want to read this. All right, because they're withholding something from you. Okay, Income Withholding for Support Act. That's what you want to read. All right, or any other of its predecessors. Right, and then it says the public aid. It gives us a section of the Illinois Marriage and Dissolution of Marriage Act, and then the Non-Support of Spouse and Children's Act, and the Revised Uniform Reciprocal Enforcement of Support Act, right? And Illinois Percentage Act, from engaging in conduct that would not cease a reasonable person's mental or physical illness. For the purposes of this subsection, obligor means an individual who owes a duty to make periodic payments under a court order for the support of a child. Arrears means the total amount of the obligor's unpaid child support obligation. A collection agency may not impose a fee charge, including costs for any child support payments collected through the effort of the federal, state, or local government agency, including but not limited to child support collected from the federal or state refund, unemployment benefits, or Social Security benefits. No collection agency that collects child support payments shall impose a charge or a fee, including costs for a collection of a current child support payment. Fail to apply collections to current support for as specified in the order for support by applying collections to arrears or other amounts, or designate a current child support payment as arrears or other amounts owed. In all circumstances, the collection agency shall turn over to the obligee all support collected in a month up to the amount of the current support required to be paid for that month. So what they're doing is a certain amount is supposed to already be paid for you. So what they're doing, whenever they do what they call an offset against you, instead of them paying that amount for you, they collect up to that amount from you that's supposed to be given to you. That's what this is saying. It says that's what this is talking about. It says in all circumstances, the collection agency shall turn over to the obligee all support collected up to a month collected in a month up to the amount of the current support required to be paid. So they're collecting the amount from you that's required to be paid by the order that they issued for you. So they issue an order, and the order would have paid the child support. But since you didn't pay the order, they're collecting up to the amount of the order every month from you. That's what this is talking about, right? As any fees or charges, including costs retained by collection agency. See? Retained by collect. I'm just showing it to you. I want you to see it. The agency shall provide documentations to the obligee demonstrating that the child support payments resulted from the actions of the agency, right? After collection of the total amount of the arrears, including statutory interest due as of the date of the execution of the collection contract. The what? It's a collection contract. No further fee may be charged. The Department of Professional Regulation shall determine the fee rate of not less than 25%. All right, so let me go down some. But I don't want to read everything because it go a little bit deeper, right? See, this right here is talking about a person, association, partnership, corporation, or other legal entity acts as a collection agency when he or it engages in the business of collection for others. So when they collect something that's yours, like your debts, then they're acting as a debt collector of any account, bill, or other indebtedness received by assignment or otherwise accounts, bills or other indebtedness from any person owing or controlling 20% more of the business receiving the assignment, with the purposes of collecting monies due on such account, bills and other indebtedness, sell or attempt to sell or give away or attempts to give away to any person other than one registered under this act, any system of collection letters, demand forms, or other printed matters where the name of any person other than that of the creditor appears in such a manner as to indicate directly or indirectly that a request or demand is being made by any person other than the creditor for the payment of such sums or sums due or asserted to be due, buys, accounts, bills, or other indebtedness with recourse, and engage in collecting the same, right? So it's talking about anybody that buys anything and then engage in the same of trying to collect what they purchase, right? Now let's go down. You see. All right, this is talking about how they got to create the forms. Let me see. I'm trying to find a specific part. I ain't read this in a minute. All right, it's talking about the license that they got to get. Now I want to show you. Right here is talking about an assignment for collection. An account may be assigned to a collection agency for collection with title passing to the collection agency to enable the collection of an account in the agency's name as assignee for the creditor provided. The assignment is manifested by a written agreement separate form from, and in addition to any document intended for the purpose of listing a debt with the collection agency. The document manifesting the assignment shall specify and state and include, right? And it goes into all of that, right? Let me go down some though. I'm trying to see. But this is a pretty long act, yo. It's not short. And I done read this whole thing several times, but I'm trying to find. It's a part of here where it talks about. It's kind of like the Fair Debt Collection Practices Act. See right here, where it's talking about. I think this is where it starts at right here, if I am mistaken. All right, because it's talking about how they threaten to arrest you, threaten to seize or attach a sale, a debtor's property where such action can only be taken pursuant to a court. This is what the Fair Debt Collection Practices Act was just talking about. But what it was saying that they should make no threats unless they really mean to do it, right? Disclosure or threaten to disclose information adversely affecting a debtor reputation for credit worthiness with knowledge the information is false, initiating or threatening to initiate communications with a debtor's employer unless it has been a default of payment of the obligation for at least 30 days, right? See, it's talking about communicating with the debtor's family. Then it talks about communicating with the debtor or any member of his family, right? Talks about how that's supposed to go. Then it talks about all this threatening and all this profanity and, threatening, talking about what they're going to do to you, right? All this is within the Fair Debt Collection Practices Act, right? Let me go down some. Misrepresenting the amount of the claim or the debt. Remember, this in the Fair Debt Collection Practices Act. We were just reading this. I just read this in the FDACAP, right? Representing that an existing debt may be increased by an addition of an attorney's fee and all of this stuff. So you got to go in here and read this stuff, right? Because it breaks it all the way down. You go down. So he talks about how they threaten you with their attorneys and all of that. Let me see. All right. So in the state of Illinois, right? Let me say this so you can understand what you're actually reading. All right. So in the state of Illinois, instead of like the FDACAP is a federal law and it deals with federal obligations, even though each state is a federal state and they trying to act like they're not federal. They are all federal states because they're all under the District of Columbia, right? So, but each state has its own public policies. It's like an independent state of its own, right? And what this is that I'm reading, this is actually the FDACAP written into their state code, codified, right? That's why when you're reading it, it got a lot of the same things that the FDACPA got, but when you're dealing with Illinois, instead of you coming with federal law to bring a claim for a violation of those same acts, you have to find that same law within your state. And like when you find the Collection Agency Act in your state, which is the same thing as the Fair Debt Collection Practices Act on the federal level, now you can use this act rather than using, and then you can reference the FDACAP. See what I'm saying? In reference to this act. You see what I'm saying? And that's how you actually enforce the law upon them. You got to actually find like stuff like this. All right. And then it talks about complaints upon receipt of a consumer's complaint alleging violation of this act by the collection agency. The department may require a written complaint on a form provided by the department. The form shall identify the collection agency and provide for the complainant, a summary of the nature and the alleged violations and the fact that allegedly support the complaint. The form shall include a provision, for the complainant to attest that the alleged allegations therein is true. The statement shall be in the following form. I declare under the penalty of perjury that the above statements are true and accurate. I hereby authorize the Department of Professional Regulations to make further inquiries to verify this statement. I understand that the content of this complaint shall be forwarded to the business or the person the complaint is directed against. I authorize the collection agency to disclose any information in my file to the Department of Professional Regulations. Upon receipt of the complaint form, the department shall furnish a copy of the complaint to the accused collection agency. The department may demand all agency records concerning the complaint. The director may order the investigation to determine the validity of the complaint. However, an investigation shall not be ordered by the director unless a written complaint has been received from the consumer. All communications and investigations pertaining to a complaint, other than a complaint alleging criminal activity, shall be conducted with the knowledge of the proprietor, partner, and the corporate officer of the collection agency or his designee. Okay, so like when they like these acts are not just acts telling you like what they have, what rights they have, and what rights you have. Like I said, all these agencies that's collecting child support are debt collection agencies, and they fall up under the FDACAP. And each state has a codified code that deals with the collection by debt collection agencies within their states, whether it's child support or not. And you see, the thing is, when you hear child support, you think of something totally, it ain't nothing but a debt collection. You treat it the same way you treat any other debt collector. That's how you do that. If you stop being so feared in the name, IRS, the this and that, y'all get fearful when y'all hear certain names, but these are administrative agencies. They all fall up under the administration of the United States, regardless of who they are. You know what I'm saying? And once you understand that and you learn how to administrate your obligations, then you can do things that are required by law. And then they have to comply with law. You see what I'm saying? And that's just how it goes. Let me see. I think I read it all, y'all. It goes into everything. Unlawful, like, because in here it says that they got to have a license to practice law. It didn't say nothing about it said they had to have a license. And I already showed y'all in Illinois Attorney Act that they have to have a license. But this is something else too that you want to actually read for those who didn't know that that child support collection agencies that's what they are. They are collection agencies collecting child support from an order issued to them by a court, which gives them the rights to enforce the order or collect the order as a collection agency. So now you know what they are. You should be able to deal with them accordingly. You know what I'm saying? A lot of people don't, everything is by consent. You're consent to everything. So with that said, let me see if I got one more thing I want to tap into before I get ready to get up out of here. That's the child support demonstration. Now let me see. I'm gonna give y'all one more demonstration. Let me see what I want to do. Let me go into my trenches. I'm gonna go into the trenches. I'm gonna pour something up juicy for y'all, man. Woo! Boy, y'all know Brother Isaiah got that info over here. I got that info. Like when I promise you, y'all make sure y'all tap, y'all share the live, man. Y'all make sure y'all share the stuff out, man. I promise you, you come here, you ain't gonna never end up empty. You're gonna always come out with something that's gonna build and make you a better person. Like we said, building better minds help you build a better tomorrow for yourself. Understanding things that you didn't even know. You know, like why they scrutinize collection agencies, because anytime somebody collects a debt, they're collecting the interest of somebody else. That interest that they're collecting could be paying settling your obligation, but if somebody's collecting it, then you ain't receiving no benefits. Somebody collecting on your benefits. You know what I'm saying? And now you understand what's going on. That's why you should dispute any debt collection. Nobody collect my interest. Oh, this is my debt. You know what I'm saying? You better claim that, please. You better claim it. You better claim it. Claim it. Let me see. And y'all make sure y'all go to buildingbetterminds.info. Hey, and check us out, man. We got a lot of great things. We got step-by-step courses that teach you how to do certain things with forms and documents. Got a lot of things on there, man, for the people, man. All you got to do is be willing and able to apply yourself. I promise you, you can't go wrong with us. That every direction we lead you in is going to always lead you into the right direction, to the right information, opening up the right doors that you've been trying to open. You just didn't know where they existed, right? So, yeah, you want to come here, man. Let me show you a little something today. What's going on? Oh. All right, let me see what I'm gonna pull up. Hmm. Yeah, I'm just trying to look through and see what I can find real quick. Scope of rules definition. All right, so we're gonna read this. I'm gonna pull this up. Yeah, y'all gonna enjoy this one right here. Now, I'm just showing you that Brother Isaiah do have that information. All right. So, you can't go wrong with a brother like me. Uh, all you can do is be educated beyond reason. You get some education over, be mind blowing education. I'm talking about, ask anybody, they'll tell you, man, mind blowing. To the point to where you be like, it's unbelievable. How does this man even know? How you even know this stuff? Where did you? They be like, man, how do you find this? how do you, how do you how do you do it, brother Isaiah? I just tell them, man, it's in the blood. It's in my blood, y'all. It's in the blood. All right, let's get it. Let's get it. Let's get it. Bam, bam. So we at Title 26, CFR 26, 601.501. These are the scope, rules, and definitions. Let's see. Let's get to it. The scope of rules. The rules prescribed in this subpart concerning, amongst other things, the representation of taxpayers before the Internal Revenue Service under the authority of a power of attorney. Okay, first of all, let's see the representations and the highlights. So it says representations, the act performed on behalf of the taxpayer by a representative in practice before the Internal Revenue Service. Representation does not include the furnishing of information at the request of the Internal Revenue Service of any of its officers or employees. Okay? So this deals with the representation of uh, the taxpayer before the IRS dealing with a power of attorney. Now, it says a power of attorney is a document signed by the taxpayer as principal, by which an individual is appointed as an attorney in fact, right, to perform certain specified acts or kind of acts on behalf of the principal. Specific types of powers of attorney include the following: a general power of attorney. The attorney, in fact, is authorized to perform any and all acts the taxpayer can perform. A dual power of attorney. A power of attorney which specifies that the appointment of the attorney, in fact, will not end due to either the passage of time, authority conveyed will continue until the death of the taxpayer or incompetency of the principal. The principal becomes unable or he's a judge incompetent to perform his or her business affairs. And then you got the limited power of attorney, which is limited in any fact or facet. Power of attorney authorizing an attorney, in fact, to perform only certain specified acts as contrast to a general power of attorney authorizing a representative to perform any and all acts the taxpayer can perform. Practice before the Internal Revenue Service. Practice before the Internal Revenue Service only or any of its personnel relating to the taxpayer's rights, privileges, or liabilities under law or regulations administered by the Internal Revenue Service. Such presentation includes the preparation and the filing necessary documents corresponding with the communications to the Internal Revenue Service and the representation of the taxpayer at the conferences, hearings, and meetings. Principal, a person, taxpayer who appoints an attorney in fact, right, under a power of attorney, recognized representative, an individual who is recognized to practice before the Internal Revenue Service under the provisions of 601.502. Representation, acts performed on behalf of the taxpayer by a representative in practice before the Internal Revenue Service, right? And then we got substitution of representation, tax information, authorization, document signed by the taxpayer, authorizing an individual or entity, corporation, partnership, trust, or organization designated by the taxpayer to receive and inspect confidential tax information in a specified matter. Right? So all of this right here talks about the taxpayer representation before the IRS. Right? These rules apply to all offices of the Internal Revenue Service in all matters. In all matters, the application of each tax imposed by the Internal Revenue Code and the regulations thereunder for each taxable period constitutes a separate matter. Okay? For all tax matters under the jurisdiction of the Internal Revenue Service and apply to the practice before the Internal Revenue Service as defined in 31 CFR 10.2A and 10.7A. Now let's go to 10.2A. As used in this part, except as otherwise provided, otherwise, an attorney means a person who is a member in good standing of the bar of the highest court of any state. Now, did we just read the Attorney Act that they had to have a license from the Supreme Court? Now listen to this one. You see how, and you see what I mean? How an attorney means a person who is a member in good standing of the bar of the highest court of any state, territory, or possession of the United States, including the Commonwealth or District of Columbia, certified public accounting. So all this is part A, right? and for special provisions relating to alcohol, tobacco. All right, so it says these rules detail the means by which a recognized representative. Now, what's a recognized representative? An individual who is recognized to practice before the Internal Revenue Service. So, to be a recognized representative, you got to be recognized before the Internal Revenue Service to represent the taxpayer. Such authority must be evidenced by a power of attorney in a declaration of representatives filed with the appropriate office of the Internal Revenue Service. In general, a power of attorney must contain certain information concerning the taxpayer, the recognized representatives, and the specific tax matters for which the recognized representative is authorized to act. A declaration of representatives is a written statement made by a recognized representative that he or she is currently eligible to practice before the Internal Revenue Service and is authorized to represent a particular party on whose behalf she acts, right? Then we got definitions: attorney in fact, an agent authorized by the principal under a power of attorney to perform certain specified acts or kinds of acts on behalf of the principal, right? And the principal is a taxpayer, i.e., taxpayer. It didn't say man, didn't say woman, right? It says a person, i.e., the taxpayer. You know what I'm saying? Like it's right there. It's just right in your face, right? Centralized authorization file. This is the CAF number that they give you. An automated file containing information regarding to the authority of the person appointed under the power of attorney or designated under a tax information authority. So when you do the Form 56 and the 2848, then you become on the record the representative, right? Treasury Department circular, right? Codified 31 CFR Part 10, which sets forth the regulation governing practices before the Internal Revenue Service. So if you want to know about the practices, the authority before the Internal Revenue Service, you want to go and read this, right? And this is when I say helping each other, this is what I mean. Like really helping each other, like showing people what they really need to know and what they really need to be paying attention to in order to deal with some of the things that's happening within their lives. Because a lot of people, I understand you want to make a little couple of dollars here and there, but at the same time, if you don't know things, then don't act like you know. Tell the truth so that people can know the truth and lead the people that have the information that can teach the people, allow us to do what we came here to do. Get out our way. You know what I'm saying? So we can establish what needs to be established so that the people can learn, right? The commissioner shall establish the office of professional responsibility and any other offices within the Internal Revenue Service necessary to administer and enforce this part. The commissioner of the Social Security Administration shall appoint the director of the office of the professional responsibility and any other Internal Revenue Service officer to manage and direct any office established to administer or enforce this part. Office established under this part include, but are not limited to, the Office of Professional Responsibility, which shall generally have responsibilities for matters relating to practitioners' conduct and shall have exclusive responsibility for discipline, including disciplinary proceedings and sanctions, and an office with responsibility for matters related to the authority to practice before the Internal Revenue Service, including to act on applications for enrollment, to practice before the Internal Revenue Service, and administering competency testing, the continuing education. Officers and employees within the office established under this part may perform acts necessary and appropriate to carry out the responsibility of their offices under this part as otherwise prescribed by the commissioner. the Commissioner of the Internal Revenue Service. All right, so then we go to the next part. Now we got the definition. This was what we was just reading, right? Now, who may practice? An attorney who is not currently under the supervision of disbarment from the practice before Internal Revenue Service may practice before the Internal Revenue Service by filing with the Internal Revenue Service a written declaration that the attorney is currently qualified as an attorney and is authorized to represent a party or parties, notwithstanding the preceding sentence. Attorneys who are not currently under the supervision or disbarment from the practice before the Internal Revenue Service are not required to file written declarations with the IRS before rendering written advice covered under this. But so when they represent you in court, they put in with the IRS. See what I'm saying? To represent you, because you don't know how to represent the name yourself, right? Then you got public accountants, enrollment agents, right? All these different people can enroll with the IRS as a representative. Registered tax return prepared, right? And any individual qualified under 10E eligible to practice for the Internal Revenue Service, right? So let's see. Who is this? All right, so it's talking about a tax preparer. And then you got government officers and employees and others. So this is how, when you go to court and they trying to get you to get an officer and all that so they can represent you before the IRS, because they know that they're a tax court. they know that they're a tax court. Unless they got a delegation of authority from Congress, then they're a tax court. We know that. Everybody, we already know now. We know the truth now. You know what I mean? It is what it is. So there you go, right there. So the main thing is making sure you're the representative of your taxpayer before the IRS. No one else should be representing the taxpayer before the IRS before you, right? Eligible to become enrollment agent. You know, so if you want to become an enrollment agent, this is how you do that. Okay, now let me go back. All right, so all this deals with all of their different practices before the IRS, the sanctions, and all the different things. All right, so when you're dealing with this act, like I said, as you can see, if you tap on any link, you can be in a whole different section, reading something totally different, you know, and dealing with a different aspect of what it's talking about. A lot of people don't like to read, but man, you got to be a proficient reader and you got to be able to read and comprehend and be able to move forward. And, you know, if you feel like you need to jot down notes or whatever, you got to be able to do all that and be fast about it. Right. So what I'm showing you is that you got a declaration of representative, the delegation of authority to act to perform recognized representative whereby authority given under a power of attorney is delegated to another recognized representative after delegation is made. Both the original recognized representative, right, and the recognized representative to whom the delegation is made will be recognized to represent the taxpayer, right? Form 2848, power of attorney and declaration of representatives, the Internal Revenue Service power of attorney form, which may be used by a taxpayer who wishes to appoint an individual to represent him before the Internal Revenue Service. All right? So you can use that. A matter, application for each tax imposed by the Internal Revenue Service and regulations thereunder for each taxable period. Office of the Internal Revenue Service, right? The office of each district director. Each one of us got our own district director. The office of each service center, and the office of each compliance center, and the office of each regional commission, and the national office constitute separate offices of the Internal Revenue Services. Okay, so you got to understand, like, all of these different things are applicable to a lot of different things in reference to the district director is very connected to the treasury in reference to offsetting debts and everything. All these different things play big parts in a lot of different things that we're doing. A lot of people don't even know that they can uh, tender payment to the general postal master. Like instead of, because your mail go directly to him anyway, so you might as well endorse it to him, right? So when you understand, like, it's certain things that you can do that a lot of people don't do because they don't know. You just don't know. Power of attorney, a document signed by a taxpayer as principal, right, by which an individual is appointed as an attorney in fact to perform certain specified acts of a kind of act on behalf of the principal, right? Then it goes into all the different powers of attorney, right? Recognized representatives, tax information, conference substitution of information, all right? All these different things, right? So main thing is to understand that you need to have representation of your taxpayer before the IRS, right? A recognized representative is an individual who is appointed as an attorney, in fact, under the power of attorney, and a member of one of the categories described in 601-502B, and who files a declaration of representative as described in 601-502C, right? Categories: attorney, individual, member. All right, so it go back to these. So practice based on relationship or special status with a taxpayer. Any individual authorized to represent a taxpayer with whom a special relationship exists, right? For example, an individual may represent another individual who is his or her regular full-time employer or member of his or her immediate family. An individual who is a bona fide officer or full-time employee of a corporation or certain other organizations may represent that entity. I didn't say it. I didn't say it. I'm just showing it to you. I'm just showing it to you. Okay? I'm showing it to you. Okay? Because everything is funneled through the revenue service. Okay? So remember, an individual authorized to represent a taxpayer, but he has a special relationship. Let's go to the special relationship. One representing oneself. What? Wait a minute. Hold up. Oh, wait a minute. Wait a minute. I said don't give them too much, man. You're giving out too much. No, I'm not. I'm supposed to teach the people. I'm supposed to enlighten my brothers and enlighten my sisters. Why wouldn't I do? That's what the love is for. All I ask is that they love me in exchange, that they love the brother the same. Give me the same love that I'm giving to you. Reciprocate the same. Recognize your brother. That's all. That's all I ask you to do. Share out my stuff and help me reach more. That's all. Help me get the recognition that I deserve for doing the work of the creator, because I'm doing the work and I'm actually teaching you things that I feel that are designed solely for me to teach. Not to say that other people can't teach, but this is solely my mission and what I have, right? Representing oneself, participating in rulemaking, limited practice, and special appearance. Right? Representing oneself, participating in rulemaking, limited practice, and special appearance. Representing oneself. Individuals may appear on their own behalf before the Internal Revenue Service, provided they present satisfactory identification. Participating in rulemaking. Individuals may participate in rulemaking. as provided by Administrative Procedures Act, C5 USC 553. Limited practice in general, subject to limitations in paragraph of this section. An individual who is not a practitioner may represent a taxpayer before the Internal Revenue Service in the circumstances described in this section. C1. Even if the taxpayer is not present, provided the individual presents satisfactory identification and proof of his or her authority to represent the taxpayer. The circumstances described in paragraph C1 are as follows. Any individual may represent a member of his or her immediate family. A regular full-time employee of an individual employer may represent the employer. A general partner or regular full-time employee of a partnership may represent the partnership. A bona fide officer or a regular full-time employee of a corporation, including parent subsidiaries or other affiliate corporations, associations, or organized groups, may represent the corporation, association, or organized group. A regular full-time employee or a trust, receivership, guardianship, or estate may represent the trust, receivership, guardianship, or estate. An officer or a regular employee of a governmental agency or authority may represent the governmental unit, agency, or authority in the course of his or her official duties. An individual may represent any individual or entity who is outside the United States before personnel of Internal Revenue Service when such representation takes place outside the United States. Limitations. An individual who is under supervision or disbarment from the practice before the Internal Revenue Service may not engage in the limited practice before the Internal Revenue Service. Under paragraph C1 of this section, a commissioner or delegee may, after notice to opportunity for a conference, deny eligibility to engage in limited practices before the Internal Revenue Service. Right? It makes sense. It's the Internal Revenue Services. Everything we're dealing with is concerning revenue. And this is the Internal Revenue Service when you're dealing with services pertaining to revenue. You know what I'm saying? It makes all the sense in the world, right? An individual who represents a taxpayer under the authority of paragraph C1 of this section is subject to the extent of his or her authority to such rules of general applicability regarding standards of conduct in matters as prescribed in the Internal Revenue Service. So let's go to C1 again up top. I want to make sure you know what it is. 1C. An individual who is not a practitioner may represent a taxpayer before the Internal Revenue Service in the circumstances described in paragraph C1. All right. And you can appear on your own behalf. You need satisfactory evidence that you're the taxpayer. So, like say when you do a DBA or something like that, then you're appearing on behalf of oneself as the business. You see what I'm saying? So things like that, like this stuff right here is very important for understanding, right? Returns, preparation, applications, rules of other individuals, right? So, because all of this deals with tax returns and preparing for taxes and stuff like that. So I ain't gonna go too far into it. You know, I showed you a little something, like I said. I was gonna give you a little something, just something for you to tap into. Y'all can go and eat that at your own leisure and things like that. But it's very important that you understand the power of attorney, right? Now, you might say, well, I'm going to show you this right here. Because it takes time for people to understand certain aspects of commerce. It ain't something that you learn overnight, right? But it's something that you learn as time goes on. All right, so when you go here, we're talking about endorsements and payment of checks drawn on the United States Treasury. All right, so when you're dealing with the United States, you're dealing with a bankrupt entity. So anything that's approved by this bankrupt entity will be an obligation that it owes to you because it's bankrupt. So if you get approved, you should never have to pay a bankrupt entity anything. If anything, the entity owes you, right, value for providing a means for it to have a lease or a mortgage note that it can draw from or trade on. You're the one entitled to receive compensation. But due to lack of understanding and a lot of deceptive acts and practices, a lot of people are unaware of these things, right? So these regulations in this part prescribe the regulations for endorsement and conditions for payment of checks drawn on the United States Treasury. The regulations also establish procedures for collections of amounts due the United States Treasury based on claims arising from breach of presentment guarantees by presenting banks and other endorsers of Treasury checks when checks bearing material defects and alterations are forged dispersing officers' drawers, signatures are presented for payment and are paid. Standards contained in this regulation supersede existing federal common law and extend that they are inconsistent with federal common law rules relating to counterfeit checks under the provisions of regulations. The risk of loss on certain counterfeit checks is placed on the presenting bank and other endorsers unless the Treasury fails to timely reclaim the check payment in accordance with. In this regulation, right? So it's talking about all Treasury checks, counterfeit checks, and all these different things, right? So when you go in here, the first thing it talks about is an administrative offset. All right, that's the first definition. Administrative offset, and it has the same meaning here in this part. So when we go here and we click on it, it says in this chapter, an administrative offset means withholding funds payable by the United States. So that means that when somebody is doing an administrative offset, you could have got approved for rents, but instead of them paying the rents, they're withholding the rents, and they're doing an administrative offset against you because the funds that you got approved for were payable by the government for you to have rents for that apartment, but somebody else withheld those rents, right? And they're doing an administrative offset to are held by the United States for a person to satisfy a claim. So the United States approved you for rent on a lease to satisfy the lease, but the holder of the lease is withholding the rents that's been approved on the lease and doing an administrative offset and collecting rents directly from you and withholding back what the government has already scheduled to be approved for you. You see what I'm saying? Now, when you understand that, you understand, like, wait a minute, what the hell? So you mean, so y'all doing an offset against me? Okay. So, so now you start getting into the consumer reporting agencies, all these different things. Now, I'm not gonna get into this, right? So I just want to show you something. Executive, judicial, or legislative agency means a department, agency, court, administrative office, or instrumentality in an executive, judicial, or legislative branch of the government, including government corporations. So when you're dealing with the court, you're dealing with a government corporation. You're dealing with an agency, right? An administrative agency, right? Understand, understand that. And then a lot of y'all don't get this right here. So you keep saying you in debt, and I keep telling y'all not in debt. A consumer is not in debt. A consumer does not apply for debt. I've never met a consumer in my life that wanted to apply to be in debt. Show me one consumer that applies for debt. Show it to me. Point him out. Show him where I can hit him in his head. Like, you got to be crazy. You apply for a debt, boy, you got to be out your mind. I believe we apply for credit. I don't think we apply for debt. I think that we apply for credit, but credit comes in the form of a debt. Okay? So when you receive your credit, it might appear to be a debt, but if you misinterpret what it is, of course you're going to act wrong because you think it's something that it's not. It's an alleged obligation because it's really not your obligation. You just think it is, right? Non-tax debt, all right, means with respects to any debt or claim, any debt or claim other than a debt or a claim under the Internal Revenue Service. So what it's trying to tell you is a non-tax debt is any debt that's not collected by the Internal Revenue Service. If it's not a debt due to the government, if it's not an obligation of the government, then it's non-tax. All taxes are due to the government. No, wait a minute. Hold on. You ain't feeling me though. Hold on, you ain't feeling me though because you keep thinking you got a debt. And I keep trying to tell you that you don't have no debt. You are in credit. You're under insurance. All right? It's a non-tax debt. All right? It's really either a debt. The reason why it's a debt because it's an obligation. So it comes in that form. All obligations, whether it's credit, they're going to come in the form of a debt because it's showing that performance is due. That's all a debt is creating some sort of performance and obligation. All right? But either it's a debt or it's a claim of a right. It's either a claim, it's either you are indebted under it, or either you have some sort of right in it or a right against it for a particular purpose that you might be using it for. So it all depends on your perception of it, how you see it. But a real debt is something that's owed to the government that will be collected by the Internal Revenue Service. Just like if you owe a debt to the government now, the IRS will bill you, okay? In subchapter 2 of this chapter, subsection A8 of this section, the term claim or debt means any amount of funds or property that has been determined by the appropriate official of the federal government to be owed to who? Oh, wait a minute. Who they say that it's owed to? Huh? Wait a minute. I thought they said you owe the debt, but you're not the U.S. The U.S. person is the United States. That's why it's called a U.S. person, because it's actually the United States as a person in relationship with you. You're in relation with the U.S. as a person in relation to you. Hold up. I know I'm talking in codes, but you got to be with me, though. You got to follow me because I'm trying to teach you something here because hold up, ain't nobody else showing it to you, so let me show it to you. Claim, for the purposes of this title, each of the term claim and debt include the amount of funds of property owed by a person to a state, including any past due support, child support, being enforced by the state. Being enforced by who? By the state. The District of Columbia. Who is the state? What state are we talking about, y'all? Huh? What state are we talking about? Wake up. You gotta wake up, man. How long you gonna stay asleep? Huh? By a person, organization, or entity other than the federal agency. A claim includes without limitation funds owed on account of a loan made, insured or guaranteed by who? By who? By who? Okay, keep playing with it. Including a deficiency or any difference between the price obtained by the government in the sale of the property and the amount owed to the government on the mortgage. I thought you owed the mortgage company. Wait a minute. Hold up. Wait a minute. Simon, the United States is kind of tricky, man, how they write their laws and stuff, right? Expenditures of non-appropriated funds, right? Including actual and administrative costs relating to shoplifting, theft, detection, and theft prevention. Overpayments, including payments, disallowance, and audits performed by the Inspector General of the agency administering the program. So did you know that every company got an Inspector General? You know, T-Mobile got an Inspector General. The gas company got an Inspector General. Did you know that? Did you know? You didn't know that? They even got an accountant. All of that in their department. Yes, sir. Yes, sir. Any amount the United States is authorized by statute to collect for the benefit of any person. So you mean to tell me the United States is collecting for the benefit of any person? So you owe the person an amount to be paid by the United States and you didn't pay it. So the United States collect through its administrative offset program against you through that same agency to collect what you didn't pay. So now you paying that agency something that the government is collecting for non-payment, right? The unpaid share of any non-federal partner in the program involving a federal payment in a matching or cost-sharing payment by non-federal partner, any fines or penalties. Right now, why is it that you don't know that you owe the federal government for all these obligations? Why is it that you don't know that? Why is it that you don't compute that these are not debt collection agencies that you're dealing with? And then if they're doing any administration of a debt, they got to be administrating something that the government allowed them to administrate, because you're in a government program. We're in bankruptcy. All these programs, lease programs, mortgage programs, these are all sponsored government programs, y'all. Y'all got to understand that. And when the government is involved in any program, the government requires disclosures like truth in lending, the finance charge. Anytime the government is in a particular transaction, disclosures are required to be provided so that you know who the true creditor is. But if you're incompetent, you're never going to know who the creditor is because you don't know how to read federal law. You see what I'm saying? Like, real. I'm just going to tell you what's real. Now, look, let me go on down, right? I'm going back, man, because y'all can thank me later. Yay. Check this out. So in this act, let me go back. Go all the way back. So when you go all the way in here, you go all the way down. They got right here, it's called the appendix, right? A, part 240, optional power of attorney forms, right? So they have power of attorney in their applications, right? And the physical services form 233, general power of attorney, individual. This power of attorney form may be executed by an individual, an incorporated partnership, or a sole owner for checks drawn on the United States Treasury in payment, number one, for redemption of securities, or for principal and interest on U.S. securities, or for tax refund, and for goods and services, right? So you can use this form in order to charge the United States for any tax refund, for any redemption of any security. You know how we do the endorsement to the United States for redemption? You can actually use this power of attorney along with that endorsement. That's what this power of attorney is for, right? And it got 2 or 3 different types of powers of attorney. Let me pull up one of them real quick. I'm going to pull up Form 231. Now, you can use this form for, like, if you representing your children, or if you're a husband and you got a wife and you want to, you want to be power of attorney and you want to represent your wife, uh, utilizing this form in order to process payments with the Treasury on her behalf. And you want to use this and attach this to the Form 2848, right? When you're using the Form 2848 and you're saying you're the power of attorney for a specific entity, whatever, you also want to issue this. And you want to make sure you get the right form for the particular type of entity that you're actually issuing it for. They got different ones. Make sure you don't use this one for no corporation, because that wouldn't be in compliance. This is for an individual. So make sure that you understand and you read to get an understanding. And it says, no, by these presents, and then that'll be your name and your address, does hereby appoint, and whoever you appoint, right, as your representative, right, as his or her attorney to receive, endorse, and collect checks payable to or to the order of the undersigned, right, drawing on the United States Treasury, right, and to execute in the name and on behalf of the undersigned all bonds, indemnity applications, and other documents which may be required by law or regulation to secure the insurance of substitutes for such checks, right? And to give full discharge for the same. So what it's saying is certain documents, certain items that you given to the Treasury, right, on behalf of somebody you representing, in exchange to be substituted for a check. So I got a lease for rent, but I'm gonna give it to you in exchange that you substituted for a check from you to whoever, right? And give the full discharge for the same. Granted to said attorney full power of substitution and revocation, hereby ratifying and confirming that all said attorney or his substitutes shall lawfully do and cause to be done by virtue hereof, right? And then, you get your little witness, then the notary, and it's signed. And then it got the instructions, right? Which you should read this first, but we always do stuff backwards, right? So we fill out the form first, then we read the instructions last, right? So instructions for physical service form 231, read carefully. It says this general power of attorney may be used for endorsements and collection of checks drawn on the United States Treasury in payment of principal and interest on public debt obligations or obligations guaranteed by the United States tax refund and payment for goods and services. Man, come on, man. I could just drop the mic right now, man. Like, for real. Like, cause when you first start learning, I know people have been following me for years and been knowing about this document, but their knowledge was not there to understand what it really meant. Cause you gotta grow with this knowledge. But I bet you now they go back and they see and they read, they be like, man, this God, like, how did you even find this form, Brother Isaiah? Because believe me, I'm the one that put this out into the atmosphere. All right. I'm the first one discovered this form and put it out there for people to know about it. You go back and check the records, you'll never find nobody with a record older than any video of mine showing you this form right here. I got the oldest video out when it comes to this form. Nobody can go farther than me as far as this because I put it out there. All right. Now check it out. Now this form right here, because they ain't gonna put it out there for us. They most definitely weren't going to tell us about this. All right. So this general power of attorney should not be used by taxpayers and their representatives to authorize the Internal Revenue Service to mail tax refund checks to anyone other than the taxpayer. So you can't use this form to get them to pay somebody else your refund check. You got to receive your own refund check. Now you say, what refund check? Oh, you don't know about the let's go here real quick. You don't know about the refund checks? Hold up, let me put you on game. Hold up. They like Brother Isaiah. Man, listen, I don't play no games, man. We ain't got time to be playing no game. Listen, notice to be given to the recognized representative. Remember we was just reading about the representative and I was showing you how to fill out the 2848. Y'all gonna get with Brother Isaiah one way or the other, right? It says direct contact with the taxpayer, delivery of a check drawn on the United States Treasury to recognize representative. Notice to be given to the recognized representative, direct contact with the taxpayer, delivery of a check drawn on the United States Treasury to the recognized representative. Any notice or other written communication or a copy thereof required or permitted to be given to the taxpayer in any matter before the Internal Revenue Service must be given to the taxpayer, and unless restricted by the taxpayer to the representative according to the following procedures. If the taxpayer designates more than one recognized representative to receive notice and other written communications, it will be the practice of the Internal Revenue Service to give copies of such to two, but not more than two individuals so designated. In the case in which the taxpayer does not designate which recognized representative is to receive notice, it would be the practice of the Internal Revenue Service to give notice and other communications to the first recognized representative appointed under the power of attorney. Failure to give notice or other written communication to the recognized representative of the taxpayer will not affect the validity of any notice or other written communication delivered to the taxpayer unless otherwise indicated in the document. A power of attorney other than a 2848 will be presumed to grant authority to receive notice or written communication or a copy thereof required or permitted to be given to the taxpayer in any manner before the Internal Revenue Service to which the power of attorney pertains. Cases where taxpayer may be contacted directly, where a recognized representative has unreasonably delayed or hinder an examination, collection, or investigation by failing to furnish, after repeated requests, non-privileged information necessary to examine, collection, or investigation. The Internal Revenue Service employee conducting the examination, collection, or investigation may request the permission of his or her immediate supervisor to contact the taxpayer directly for such information, right? But all this right here deals with the delivery of the checks. Once you process the payment, delivery of a check drawn on the United States Treasury, right? A check drawn on the United States Treasury, a check in payment of refund, right? Of internal revenue tax, penalties, or interest will be mailed to the recognized representative of a taxpayer, provided that the power of attorney is filed containing specific authorization for this to be done. Wait a minute, Brother Isaiah, boy, you going in today, brother. What they did to you? They did to you, brother, because you're going in today. It says, a check drawn on the United States Treasury, the authority to receive but not endorse or collect a check drawn on the United States Treasury must be specifically granted in a power of attorney. So you know how people say, oh, I got this check from the Treasury. Because I see a lot of people that show the checks, but when they try to cash them, stuff don't ever go right, right? So this is what it's trying to tell you, right? Hold up. The endorsement and the payment of a check drawn on the United States Treasury are governed by the Treasury Department Circular number 21 and amended in 31 CFR Part 240. Endorsement and payment of such check by any person other than the payee must be made under one specific type of power of attorney prescribed by Circular number 21, 31 CFR Part 240. A restriction on an assignment of claims, right? And then you got signing a tax return. The filing of a power of attorney does not authorize a recognized representative to sign a tax return on behalf of the taxpayer unless such act both permitted under the Internal Revenue Code regulations thereunder. The authority to sign an income tax return is governed by the provisions of the income tax regulation, right? And then it talks situations in which a power of attorney is not required, the substitution of tax information authorization to request disclosures of confidential tax information does not constitute practice before the Internal Revenue Service, right? Such procedures is governed by the provisions of, so anytime you're practicing, right, before the Internal Revenue Service, they got certain procedures, right? Estate matters, a power of attorney is not required at a conference concerning an estate tax matter. If the individual seeking to act as a recognized representative presents satisfactory evidence to the Internal Revenue Service official that he or she is an individual described in 601-502B, the attorney of the record for the executor, personal representative, or administrator before a court where the will is probated. And then you got B, it's all of these, either accountant, enrollment agent, other individual, right? Self-representative individual before the IRS and all this stuff that I showed y'all at first. All right. So that's pretty much it on that power of attorney, right? But just know that the power of attorney is one of the main documents that has to be submitted for representation, right? For any type of taxpayer, right? But I'm not gonna read all of this. Like I said, I just want to come on and just show you a couple of little things that for your benefit, for you, for your family, so that you can go back and you can present this information to your family so y'all can go over this information. All right. All I ask that you do is you give me some shares, some likes, subscribe to the channels, enlighten more people about this channel and what we do here at Building Better Minds. And like I said, we do have an upcoming webinar going over how to process payments correctly and with either your state or local government. And we will be going over depository insurance, how to properly utilize a debit card, how to process EFTs and ACHs and other types of transactions, and other little things secret little things that we've discovered here at Building Better Minds. And a couple of forms that may be able to help you get such things done in a quicker and more fashionable manner. But y'all go check this out, man. Like, yeah, like I said, I can't make this up, man. How important that power of attorney is, man. That you use that power of attorney. And like I said, if you're dealing in matters of taxes, matters concerning payments, and you want a power of attorney for that specific matter, it's best to use the physical service department form, right? In order to to do that. And then with the physical service department, the physical service department is the designee of the treasury, meaning that you can process all your things through the physical service department, right? All right, so when we go, you got a few of them. So you got the certificate of identity. This certificate of identity, this one right here is for the Department of Justice. Okay? And the Department of Justice has a certificate of identity, right? Under the Privacy Act, reporting for this collection of information, right? This right here is dealing with certification of identity, all right? You want to certify your identity with the department, right? In the United States of America, right? All it is, you can fill this form out. But that's like the form I'm looking for. The form I'm looking for is this treasury form. All right. Now, this is the certificate of identity. And this certificate of identity is for the physical services department. Right? This is for the physical services department. As you can see, you got FS form 0385. All right. This right here, this certificate, you have to go to your bank, right? It's required the medallion signature guarantee, right? So this is right here is a certificate you issue to the physical services department in order to verify your identity with them when you're actually doing transactions and stuff like that. So usually it'd be like you certify that most people might say, see, I can say, I'm gonna show you a couple of ways you can do this. You can say, see what I'm saying, something to that degree. I can put it like that, or I could say, I could do it like this. I can say that I certify that the name Isaiah Jakeem Bey and the People's Remedy refer to the same person whose correct name is Isaiah Jakeem of the family of Bey. I can put it like that, or I can say whose correct name is, and I can put Bay, comma, Isaiah, Joaquin. I mean, I don't know why it's in all caps. Yeah, so put it just like that. So that's because a lot of people probably try to figure out how you fill this form out. When I first came across it and I was reading it, I was like, man, what the hell? I was trying to figure out how you fill this form out. But pretty much when you realize that your legal name and your business name are one and the same, which refer to you, the natural person. You know what I'm saying? So, in that sense, when you have the right logic and you think clearly, then you can fill the form out. And the names are different because, right? One is the legal name, and the other is, right, a business name, right? The source of my knowledge is it could be the DBA, assumed name certificate, whatever. And there is now, nor was there doing like any person to whom you know by either or any of these names. Yes or no, and then please explain. Then you assign it, right? And this will go right to your bank. So, like if I open up uh, a sole proprietorship with a bank, and then I want to, certify the identity of my company with the physical services department of the Treasury. I can fill this actual form out, take it to my bank, get it stamped, send it in to them in order to, certify my identity on file with them. And then, any other forms that they have, you can use because they have multiple forms that you can use for specific things. And like this form, I showed you the power of attorney form, and then there's other types of forms and stuff that they do have that they do offer. But this is another one of the forms that you can use, right? And then it says a person who has no interest in a security must. So usually when you fill in this form out, right? This form is for like a person who, like, if you're not like if I'm acting on behalf of a non-profit or some type of entity in which I'm an officer, right? A person who does not have an interest in the security must complete and sign the form confirming the individual's identity and where to send, right? In certification, each person whose signature is required must appear before an established identity to the satisfaction of the authorized certifying officer, right? So this right here, this form is for like uh when you acting for a company, right? And you're an actual officer of the company, and you don't have a direct interest in the securities that the company is purchasing. You're just a managing person or a person uh, an officer of the company with direct authority to act on behalf of that company. But you don't own none of, or have any interest in none of its shares or anything like that. It's all for charitable purposes and things like that. This is a form you can fill out for that, you know. And I got another thing. I'm gonna have to come back on another live. I got another thing where it's like a website, right? in this website, when you go to this website, you can do any kind of FOIA request, right? Like whether it's for the Social Security Administration, whether it's for the Department of Treasury, whether it's for the IRS. I'm talking about any department that you want to request reports, information. They got this one universal site, and I don't know the name of it, but I looked up one day researching and bumped across it. And you know, I seen what it was, and then I did a couple of reports just to see what was gonna come back and stuff like that. But yeah, man, I never put the information out because I come across so much. When you're a researcher, you find way more information than actually what you put out into the atmosphere because you're constantly searching, you're constantly studying, you're constantly seeking out information. So that constantly keeps you uh, intertwined. So with what's going on. So I got one more thing with y'all, right? Show y'all this last little thing. It's gonna be my. It's gonna bring me to my conclusion, right? Yeah, they be I'm a really great researcher, y'all. And I say that with all due honesty, man. Like real. Like I'm probably one of the best I know when it comes to researching out information. Nobody I haven't met anybody yet I can match up to. But it's a lot of people that research. But this right here, I like to find pertinent information. If it ain't got nothing to do with what we dealing with, I don't wanna hear none of that garbage. And listen, don't come to me with nothing I can't use, man. Listen, for real. Only come to me with stuff that's usable. Other than that, man, I don't want to just hear a bunch of stuff. Just to hear you talk, because a lot of people like to talk. All right, this right here is called the Factors Act. All right, Her Majesty, by the will, the advice, send the Legislative Assembly of Berta enacts the following. Now you say, how does it? Yes, this applies. The Factor Act applies, right, to everything that's going on right now. In this act, a document of title includes a bill of lading, right? A dock warrant, warehouse keeper's receipt, certificate, or warrant or order for the delivery of goods, right? And any other document used in the ordinary course of business as proof of possession or control of goods, or authorizing or purporting to authorize either by endorsement or by delivery the possessor of the document, right, to transfer or receive goods. Now, a mercantile agent, meaning a mercantile agent having in the customary course of his mercantile agent's business, a mercantile authority either to sell or to consign goods for the purposes of sale, or to buy goods or raise money on the security of the goods. A pledge includes any contract pledging or giving a lien on securities, on goods, whether in consideration of the original advance or of a farther or continuing advance of a pecuniary liability. A person is deemed to be in possession of goods or of the document of title to the goods when the goods or the document are in the possession or actual custody or are held by another subject to the person's control, or the purposes are on the person's behalf. So the goods are in your actual control when you actually receive receipt of the item. When you put in an application for it, and they give it to you and you sign it, then you are at that time in possession. Whether or not the actual physical possession of the item itself remains with another person or not, you are still the holder. Okay. And you got to understand that. And that's the thing that most of us don't understand, right? Disposition by the mercantile agent. If a mercantile agent is with the consent of the owner, y'all remember when I was showing you in the Fair Debt Collection Practices Act, how they get consent? All right, so in this sense, when you're dealing with a mercantile agent, their consent comes by your signed signature. When you're dealing with a debt collector, their consent comes by communication over the phone or any interaction with you in which they communicate. All right, so if the mercantile agent is with the consent of the owner in possession of goods or the document of title to the goods, a sale or a pledge or other disposition of the goods made by the mercantile agent when acting in the ordinary course of business of a mercantile agent is valid, it is as valid, subject to this act, as if the mercantile agent were expressly authorized by the owner of the goods to make that disposition. If the person taking under the disposition, which is the owner, which is you, acts in good faith and has not the time of the disposition notice that the person making the disposition is not authorized to make it. See what I'm saying? So that's what it's talking about. It's talking about when you give a mercantile agent goods. Say you give them a installment contract, and in the installment contract, you got due installments that are due to be made applicable on specific dates. You knew of this when you signed. You just may misinterpret what it meant, but you gave that document to a mercantile agent, right? Now the mercantile agent is in possession of that document of title, right? Now any pledge or any disposition that he does with the document in the ordinary course of his business is valid as if he's doing it with your authority. It's valid as if he has the right to do what he's doing because the person whose document it is gave him the consent to do it. Now, it says right here, when you look, it says, where is it at? It says, is valid, subject to this act, as if the mercantile agent were expressly authorized. What does expressly authorized mean? I'm gonna look this up real quick. Expressly authorized. See? Expressly authorized typically refers to explicit permission, right? Granted to an agent or an individual to act on behalf of a principal. This can be written in a contract or clearly stated verbally, giving the person the legal right to bind the principal or the organization, right? Agency, a principal grants an agent express authority, right? Through express instructions to perform a specific task, such as signing contracts, or managing funds, right? In governmental, corporate. So what it's talking about, so when the mercantile agent is in possession of the goods, he's acting as if he has the express authority issued by the principal to act under that agreement, right? if the mercantile agent has, with the consent of the owner, been in possession of the goods or the document of title to the goods, a sale or a pledge or other disposition that would have been valid if consent had been continued is notwithstanding the termination of the consent. If the person taken under the disposition has not at the time of the disposition noticed that the consent has been terminated. If a mercantile agent has obtained possession of any document of title to goods by reason of the mercantile agent being or having been with the consent of the owner in possession of the goods represented by the document or any other documents of the title to the goods, the mercantile agent possession of the first mentioned document is for the purposes of this act deemed to be with the consent of the owner. For the purposes of this act, the consent of the owner is presumed in the absence of evidence to the contrary. So what is it saying? It's saying that, man, you the damn principal. You are the authority and you have the power. You know how they just see it on He-Man? I don't know how old y'all is, but you know, I'm 50. So when we was coming up, we used to watch He-Man. He'd be like, I have the power. You remember that He-Man? He-Man? Yeah, man. So you got to remember, you the He-Man, right? You the Wonder Woman. You wonder why you wonder. Because you that one. Okay? They've been telling us and giving us signs the whole time. All right? But you are the power. If you're the principal and you're assigning property to an agent, then instruct your agent. It's just like a power of attorney for an attorney. When you get an attorney, if he's assigned on your case, instruct him with a power of attorney. Give him authority to act. Make him perform. Make him your agent. See what I'm saying? Because when you're working with the courts, he's their agent. But if you put him under contract, he becomes your agent. See what I'm saying? So you got to understand that all these different companies that you're providing property to are not under contract until the principal provides written instructions in order to consummate a contract with them. See what I'm saying? So, but everything that they do with the consent of the owner, right? That's why when you go here, let me show you this. All this stuff is tied together. And you go to UCC 2, leases, right? Now, I'm showing you that when you're dealing with somebody that know what they're talking about, they can take you straight to it and show you how everything is in accordance with what I just showed you. So when they do something on any account of yours, they're doing it as if they have your consent to collect the payments on your account. But an account means a right to payment. If it's your account, then you are the one who has the right to the payments on that account, right? But let me show you that first before we get to this. Let me show you that. Show you that. All right, I'm gonna show you two things real quick and then I'm out of here, y'all. And I'm gonna catch back up with y'all. All right, so we're in UCC 9102, definitions and index of definitions. When you go here, accession means goods physically united with other goods in such a manner that the original identity of the original good is not lost, right? So every instrument shall identify the original instrument is tied to. So the rent shall identify that they coming from the lease, and so forth and so forth. That's accession. That you always know the original obligation of what these obligations are for, right? Not account, except as used in account for, means a right to payment. So if the account, if you're holding the account for me, this don't apply to you. But if it's my account, it applies to me. Account means a right to payment of a monetary obligation. See, you got an obligation, a monetary and you got a right to receive that monetary obligation as a payment, whether or not you earn it by paying it yourself, because performance is when you pay. See, whether or not you earn it by performance, that's when you pay it, right? For property that has been sold or is to be sold. So either you sold property or it's been to be sold, leased, the license, or assigned, otherwise disposed of for services rendered or to be rendered, for a policy of insurance issued or to be issued. So you saying that they supposed to be paying me for my insurance policy? That's exactly what I'm saying. Every month, the balance is due to you. Every month it says due to you, amount due. That's what it says. You're just not receiving it. They're withholding the payments from you. I keep trying to tell you that they're withholding payments. They're doing administrative offsets. I keep trying to tell y'all that. For a secondary obligation incurred or to be incurred for energy provided. This goes for electricity, gas, water, for a vessel. If you got a entity, a LLC, anything, you're supposed to be getting paid for that. You're supposed to be receiving payment for those obligations arising out of the use of a credit or charge or information contained or for the use of a charge. In a card, when you're using a debit card, credit card, when you use the card, they supposed to credit you for those balances that you use. If your card limit is $5,000 per day and you use $4,000, then they supposed to pay those charges off, and then you're supposed to be able to reuse the card. See what I'm saying? Because they supposed to give you credit, or if it's your account, you're supposed to receive payment. If you use the card, you're supposed to receive payment for any usage of the card, not be charged, but receive payment. All right. When you get charged, that means that they're not paying the card. They're making you pay. Okay. Understand that. So I wanted to show you that. Now I'm going to go to here real quick. Now, when you go here, it talks about a buyer. And we're in UCC 2A 103. A buyer in the ordinary course of business, right? Means a person in good faith, meaning you doing this with all good faith, but you lack knowledge, because faith without knowledge is useless. Okay? Okay? Everything that we read in the scripture. Okay? So understand what I'm trying to tell you. You need to get it's too many people that got faith and belief, but they lack knowledge, wisdom, and understanding. You go to church, you go to the mosque, and you got all this faith in God and all this stuff, but you lack knowledge, wisdom, and understanding of who God truly is. You know what I'm saying? It's crazy. It's crazy. Okay? It means a person who in good faith, but without knowledge of food, that a sale to him or her is in violation of ownership rights. Now, what ownership rights would you be in violation? Oh, I own the taxpayer. Oh, I'm the creditor over the legal person, the straw man. You go into a whole nother world with this stuff, man. You didn't went to La La Land on us. Like, bring your ass back home. What the hell? Where the hell you just go? How the hell we just read this and you went way to the straw man somewhere. Bring your butt back, man. You're reading it wrong. Let me read it again for you so you can understand what it's saying. All right. It says a buyer in the ordinary course of business means the person who in good faith, but they lack the knowledge that a sale to them is in violation of ownership rights or security interests or leasehold interests of a third party in the goods. It's a violation for anybody other than you to receive a right in the taxpayer's goods, right? So for a third party in the goods who buys in an ordinary course from a person in the business of selling goods of that kind, but does not include a pawnbroker. So what it's saying, if you buy goods for your account, right, without knowledge that for them to sell those same goods to you again would be in violation of your ownership once you bought them. Now let me say that again, because I don't think you understood what I just said. All right. So you bought goods in good faith, but without knowledge that the lender gonna resell those goods back to you again. All right. You don't even know you bought them. That's the crazy part. You don't know you bought the rents when you signed the lease. So when they resell the rents back to you and make you pay, you don't know that that they're double dipping because you don't know of the original sale. You don't know what a sale is. Hold on, let me put you on game. Let me put you on game. Watch this. Watch this. It's a violation. Right? Hold up. Brother Isaiah, you going hard today. I know it. It says, in law, a sale is a transfer of ownership, title to property or goods. So the lease is the title to the apartment and the rents. In order for you to become responsible for the rents in the apartment, they got to sell it to you. So a sale is a transfer of the ownership, the title, the property to the goods from the seller to the buyer in exchange for money. So they sell the title to you in exchange that you pay for it with money or other valuable consideration. It legally transfers an executory agreement. See, these are executory national agreements into an executory contract, permanently passing the risks and rights of the asset to the buyer. Okay? Wait a minute. So what are you saying, Brother Isaiah? What I'm saying to you is this, is that when you go out and you purchase a contract, they're selling not just the paper, but they're selling the amounts in the paper too. You're buying all of that. You're buying the amounts financed. You're buying the APR. You're buying the installments. You're buying all of that. It comes as a purchase product. And it should meet its warranty. It should meet its requirements. If it says it's going to produce rents, God damn it, I want to see the rents. You see? That's how you got to be looking at it, because you're buying an insured product that's already pre-computed to be paid out. Now, I know, because they never thought we'd ever learn or grow to an understanding to comprehend this stuff, but they were dead wrong. All right? They were definitely dead wrong. Okay? So, what am I trying to tell? Go back. Hold on, where did it go? So, back to what I was trying to tell you. So, it's a violation, right? When you buy goods in good faith. See, you bought those goods, right? Watch this. Let me show you something. Because you don't understand. Okay. Now, I keep trying to tell you something, and I want you to understand somebody trying to trick you. So when you put in an application for goods, you're actually asking for a sale to be made to you. You're requesting for a sale. You're requesting for a transfer of title. Now, how do you buy it? If they transfer it to you, and according to the law, that's considered as a sale of a product. Transferring the title from one party to the other, it constitutes a sale. Well, how does the consumer buy the product? Buying using a purchase order is standard business process where a buyer formally requests goods and services and promises to pay for them later once the seller accepts it, right? So a consumer can purchase goods are purchased on cash, credit, or by taking delivery of goods, right? Watch this. What does it mean What does it mean to purchase goods by delivery? What does it mean to purchase goods by delivery? Purchasing goods by delivery means the buyer pays for the item and the seller handles transporting them from their location directly to the buyer's designated address, rather than the buyer physically picking them up in the store, right? So purchasing the goods by delivery means that the buyer pays for the item. So whenever you put in an application and they deliver the goods by delivering the title, by selling the title by transfer, and then you pay by purchase. The way you buy the goods is by, in exchange, you give value in exchange for your rights to buy those goods. So the value that the lender needs in order to sell the goods is in a requested signature. The signature is all that's requested in the purchase of the consumer transaction in order to consummate a transfer of the title from the lender to the buyer, along with all associated rights and obligations. So when the buyer signs, the purchase is purchased and the goods are purchased in bulk by the buyer. Now the seller receives what was bought and purchased in the administration of applicability toward the loan to make those amounts applicable under the purchase agreement. Misrepresentation is when he misrepresents that those goods are still his and begins to proceed to collect, and the buyer fails to dispute the ownership rights of the purchase, what he bought, and understanding that those due balances are already bought by him and already been paid for, and that he's already got the rights to receive those as applicable credits that he's purchased. See, when you don't understand that, then you're not going to dispute the ownership. You're going to allow them to act like they the owner over the account. But the reason why you should be disputing, right, the account is because right here, for one, you already bought the goods in good faith without knowledge. See, you didn't know you was buying goods. See, that's the trick right here. You're a buyer. In the ordinary course of business, you're buying assets, not with cash, not with credit, on a discount. Your signature is the discounted rate that allows you to purchase. All right. So when you purchase goods on credit without knowledge that you bought them, and then they resell them to you again in violation of your ownership rights or security interests. Come on, man. Come on, man. That's exactly what they've done. And that's what they do all the time. That's a violation of your rights. For anybody to sell you something and then after you buy it, resell it to you again instead of giving you the payments that you're entitled to from the sale that was made, right? So when you bought those goods, you were entitled to receive every due balance as part of the sale made to you. They were selling you balances. They were selling you installments. They were selling you rents. That's what they were selling you. That's what you were applying for. Those are the real funds that are applicable toward the agreement that should have been recognized as part of your purchase in the time of purchase. You see what I'm saying? And you giving the instructions as on how you want all those payments to be made, applicable to your rights to purchase those goods. All right, man. I'm out of, oh man, I'm out of here. I gotta get up out of here, man. I'll be on here all day going in. Let me see. Let me look at the comments. See if I got any comments. Look in the chat. Look in the chat. What's up, fam? I see the people in the chat. Let me look at some of these comments y'all that put in here. No one ever discloses to us of the SS5 converted your private property to public property. Your labeled children and rights. Right, correct. Studying the laws of property. That's good, brother. ATM. Yes, sir. Yeah, I put this down years ago, man. Can one use the POA to instruct institutions to apply interest to the? Yes, sir. Most definitely. That's what it's for. Most definitely. But when you use the POA, all right, you can enforce your rights against the legal business if you can identify and claim that it's a business and that you have the rights to use it. But as an individual, you can use another individual to work along with you, somebody that you know that you're working with, maybe a friend, a brother, cousin, partner, somebody that you trust, right? That you can work with. Right. Those who create control, most definitely. If you create, you control. Yeah. Yeah. Any payment out your pocket, it's a donation. You just giving money away. Yeah, yeah. This ain't nothing but this a full course breakfast, man. Full course, full course. Oh no, see now you gonna have to now if you want me to really give you the real juice, you're gonna have to y'all gonna have to come to the seminar, man, because the seminar that I'm having, I mean not the seminar, the webinar that I'm having. Yeah, that's where you get all the real juice right here. This right here just to warm you up. All right, this to get you warm, show you a couple of little things to get you. You're like, damn, if he put this out, man, I wonder what that webinar gonna be like. Yeah, I gotta get that. You know what I'm saying? With all that banking stuff, man. Shoot. Hey, listen, you gotta know when I tell you that I'm a man on fire. You best believe that I'm a man on fire for real, and I got some information for you. All right. Uh, Yeah. Well, I want to thank everybody, man, that tuned in, that watched the live and stuff like that. Whichever platform you coming from, YouTube, Facebook, or TikTok, whichever platform that you watching this live from, man, I really truly appreciate you guys for tuning in. But as everything must come to a finalization, uh, I am about to bring this one to a closure. Hopefully that you learned something. I'm pretty sure you did. You learned a lot. There's a whole lot more to be learned. This right here is just to get you warmed up. I know I ain't been on here in a while, like, burning it up like I usually do, but I'm the flamethrower over here, I put them flames out there on them, boy. They be They like, man, God, leave 44 on fire over here. How you ready to run out the house? You hear me? But yeah, man, y'all stay tuned. Like I said, look on the page. I think I got it on TikTok. I gotta put one on Facebook. But y'all look for the link to sign up for the webinar this Friday. We will be having a webinar on how to properly process payments with your local, state, or federal government. You ain't gonna want to miss this one. I guarantee you ain't gonna want to miss this one. All right, you want to know how to do things? You want to sign up? Make sure you there or you square, man. With that said, I'm gonna leave you as I always do in love, truth, peace, freedom, justice, and equality for us all. Hold up. Let me see. I might be able to put the link down in the chat real quick before I leave. Let me see. so you can sign up. Yeah, let me see. Get this link real quick. Give you guys an opportunity to grab a link from the live. So if you do want to be there, because I know a lot of times you might be trying to, like, dang, I wish you'd have put it in the video, man. I want that link right now. So let me go and drop this. I'm going to put it in the chat for you so you can go there and sign up. Trust me, it'll be one of the best decisions you done made, man, to get in, to get this knowledge. I mean, all the knowledge is good. Even what I just gave you right here today, I mean, you got some people would have paid top dollar for this. I already know they paid top dollar for this type of information because it's resourceful information. It's information that we all need. It's information that really needs to be understood and really scrutinized and studied in full detail. You really got to really study this information. But listen, man, I promise you that as your brother, I would not leave you empty-handed. And that if I offer something to you, you need to accept these offers because I guarantee you're going to come out with full substance. You would never come to nothing that I give you and not leave full of information, full of resources, or full of something that you can do about it. You see what I'm saying? Everything I give is always something that's applicable, something that can be taken right now and put into play right now. You can take that power of attorney form right now and start using it right now. You see what I'm saying? This ain't something you got to wait on. See, I don't believe in that. I don't believe in giving you something. You ain't got to wait on the 2848. You ain't got to wait on the form 56. You can take those form right now and start using it. See what I'm saying? And that's what we need. We need applicable information that's applicable toward what we're trying to do. We tired of hearing a bunch of stuff that sound good. We need application. We need processing. We need to know how to make this stuff work so we can start getting the things that we need to get done, building the agencies the way they need to be built, knowing what forms, what documents, where we need to go to get the surety bonds, to get the insurance, to get the coverage, to get whatever we need. You got to learn from your enemy. Your enemy is your best teacher. When you study him, you learn everything. Man, I can show you so many things I've learned for trying to figure out what they supposed to be doing. I'm learning like, damn. If I wanted to open up my company and I wanted to do, I could do the exact same. Oh, so that's why they do that. Oh, they go and they get, so they supposed to have that on file. Oh, but if I wanted to do the exact same thing, if I wanted to be a realtor, if I wanted to sell real estate, if I got to be in compliance with those same laws that I'm using against them right now to say, where your bond at, where this at. So the same things that I'm learning is good because it's also teaching me in commerce when I decide to take flight in what I'm doing with my companies. I know certain things that I need to have in play based off the things that I'm learning about what they supposed to have, if they do have it or whether they don't have it. You see what I'm saying? But it's all a learning experience. So, man, it's a great thing, man. So with that said, man, I'm gonna bring this one to a closure. Like I said, I put the link in there for you. If you decide to want to come out, you got to this Friday. You know, it's gonna be a 2-part series. Like I said, in the first part of the series, I will be covering all the laws. I'll be going over all the different things you need to know as far as rules, regulations, what's required, how things are supposed to be. We'll be, because I don't want you to take my word. I don't believe that. I don't want you to lean on my understanding. I want you to lean on what you understand based off what I give you. So when I come, I'm going to give you the facts. I'm going to bring it to you like I did today. This ain't you. I mean, even though I'm giving my understanding of what it means to me when I say when you're acting in good faith without knowledge and all of these different things like that. And the reason why, oh yeah, let me clear this up real quick. The reason why right here where it says a buyer in the ordinary course of business means a person who in good faith without knowledge that a sale to him violates his ownership. The reason why it says that you're a buyer, but you didn't know you were buying the assets until I just explained it to you that you're purchasing the assets, and what you're buying is the rents. You're not buying the lease, you're buying the rents in the lease. You're not buying the installment. You're signing the installment to purchase the installment loans that are in it. You gotta purchase the agreement to buy the purchase, right? And when you buy that, when you sign that agreement, you own every amount due. Nobody can sell something that you own back to you. They can't collect the amounts from you if you already own them already, if you already bought them. Only way they can get that off is if you don't know you own them and you buy them again. Like crazy. You rebuying something you already purchased. Now, why is it a violation of ownership? Why? Let me show you real quick. Because I already showed it to you, but you might not didn't understand. This is the reason why it's a violation of ownership. Right here. Because according to the UCC, account means a right to payment of a monetary obligation, whether or not you earn it by performance. So if it's your account and it's in your name and somebody else is managing it and collecting what's due on that account, that's a violation of your ownership because you own the account, and the account, according to law, means a right to payment. So that means that every amount due is your right to receive that payment every month, whether it's for a lease, whether it's for a license. I don't care if it's for insurance. I don't give a damn what it's for. You own it. Okay? They say own nothing, control everything. Well, I like to see that. I sure like to see it because everything that I read says that you have a right. So if it's your account and you have a right to payment of any monetary obligation, so that means that the obligations that's due, you have a right to receive those due obligations as payment for the services, for the license, for the lease. Every obligation that you paying, you actually got a right to receive. All right? So that's why they say that when we go here, that's why it says that you bought those rents. You bought those installments. You bought whatever balances that's due on that agreement. You bought it when you bought the agreement. You bought it just by signing it. Now, why do they get to resell it back to you? How they going, if the account is now yours because you bought it and you own the account and they know it's your account because it's in your name, wouldn't it be a violation for anybody else to sell the goods in that account to you? If, right, an account means that you have a right to receive the goods as payment, those goods are your payments for the account that you purchased. But you mean to tell me T-Mobile gonna sell them to you? You mean to tell me the gas company gonna sell them to you when they're yours? Huh? And you don't see nothing wrong with it. How are they selling it to you? They sell it to you every month when they sell you a bill. Every month when they deliver a bill and make a sale to you, and you gotta receive a bill and then make a payment because they sold an item to you, that's called a sale. That even if they give it to you online, that's still a sale. Whether you got it electronically, direct payment, or whatever you're doing, you're being sold items every month. They're selling you something that you already bought. So now you know what your dispute for. You know what a billing error is all about. It's something that you must learn. And one day I'm going to come back on here and I'm going to go into the billing error. I'm going to show you some things about the billing errors that you might never seen before that go into full detail so you can understand more about what the billing errors is and what they doing wrong. So you can know how to combat it, all the stuff that they doing wrong, y'all. And with that said, man, I appreciate your time. I appreciate you tuning in. And like I said, I'll be coming back, loading y'all up with more information. Like I said, we call ourselves Building Better Minds. We are a consumer financial protection organization here for the people. And our duty is to serve the people, man. That's what we're here to do. We're here to service you, to give you rightful and correct information, and to guide you in the right direction so that you be guided on the straight path and not the crooked path, because it's a lot of crooks out here looking at your pocketbook. And with that said, I leave you as I came. In love, truth, peace, freedom, justice, and equality for us all. Salute to all my real ones.